issues around contract planning and what we need to do to ensure that we are successful as we plan to execute various contracts, especially in the procurement area. So we are beginning to note that a contract is a very, very critical item in the initial steps. And the main reason that we need to have a contract is to be able to establish a legally binding agreement between two parties. These two parties could be very many scenarios of different parties. A buyer and a seller is an example of where we need to establish a legally binding contract. And we are also saying this particular bit on contract planning and formation is very, very critical in terms of ensuring the successful execution of any project. So when we are doing it, we want to ensure there is clear communication within the contract. And we also need to ensure that we have defined expectations within our contracts, that we have been able to meet expectations of both parties, like we are referring to them. And also, we also want to have all parties protected. And it is very, very important to put all this information in the contract to be able to ensure that we get it right. We need to do what we call contract need assessment. Before we get to the point where we now have the parties signing the contract, we need to do what we call a contract need assessment, where we identify the need. So what is the problem or the issue that we want to solve with the contract that we want to give to a particular supplier? It may be in regards to the delivery of goods and services. What among those goods do you require? It should be some specific items that you need to come into the organization. So you define these particular specific items because that is our center of focus. There are services that you want to be done in your organization. So when we are talking about identifying the need, every organization has very many services that they want to receive. So once we identify that, it makes it easier now as we go into the negotiating table. We know exactly what we want, or as we go to the point of preparing the contract, we can be able to clearly indicate the goods that are required, the services that are required. And then also we define goals and objectives. What do you aim to achieve with this kind of a contract? What are the key deliverables? You can be able to clarify that. Determine also the timelines and budget. So timelines, we need to be guided by what we call SMART. As we get into the contract, we need to be very specific. We need to be measurable. We need to be achievable, realistic. And lastly, in the time bound is where we bring the conversation of determining the timelines. So we set realistic timelines for the project completion. Of course, the reason why we are setting timelines is because we are using resources. We are using, for example, financial resources. And when projects do not have timelines, then it means we continue to put in more resources into the project. But when we have timelines, we have set up a budget, it becomes very easy for us to get into the final agreement of the contract. Also, in terms of contract need assessment, we need to specify goods or services, and we are doing this. We precisely want to define exactly what do we require. We may be having a long list of goods that all of them may not be delivered at the same time. So we need now to be very, very specific. And then also look at the desired qualities and standards, where we need to outline the desired quality standards. Quality is very, very important in terms of the goods that we are receiving, the services that we are receiving. There's the need for us now to specify exactly what we want. And also volume and quantity, where we need to determine the required volume or quantity of the goods or services needed. So if it is in terms of goods, maybe we are looking at their weight. We need to be very specific in determining that particular weight, and also having that appear in our contract. There is need for us also, as we undertake contract planning and formation, to be able to develop very clear specifications. When we are talking about specifications, we could be having a number of them. Number one is what we call the functional specification. So when you are looking at the functional specification, we want to define what kind of product or service we must to do in order to fulfill its purpose. We may need, for example, also to specify the layout if we are talking about services, specific services around the construction sector. Dimensions, specifications also in terms of materials and structural requirements. All those could be appearing under the functional specification. Then we have what we call the technical specification, where we outline various technical requirements for how the product or service must be delivered. We are seeking to look various materials, technology. The conversations around the technical specification also, we need to look at the hardware. We need to look at the hardware of, maybe if we are looking at the supply of computers into an organization. So we could be looking at technical specification on the aspect of what kind of processors are we looking at for our computers, in terms of memory, what is the memory size that we are looking to have, in terms of storage, in terms of the disk space. That is what we refer to as technical specification. I request Mr. Chol Manyang to be able to mute. Chol Manyang, kindly mute your microphone. And then we also have what we call performance specifications, where we need to now specify the desired outcome or the level of achievement that is expected. These specifications are now preparing us to gear to have a final written contract that is very, very clear on the need, on what the organization requires. So we need to be quite clear around that. Then we get into the drafting of the contract now. We have highlighted the specifications, what we need to do, and now we come to the point of drafting the contract. So we look at what we call standard boilerplate clauses, where we need to utilize standard legal clauses. We can be able to, these boilerplate clauses are going to ensure the document represents or gives the full information the disclosure of full information like confidentiality, termination. Someone to kindly communicate to Chol Manyang to mute his microphone. We have specific provisions within the drafting of the contract also. When we are talking about specific provisions, is where now we bring the conversation of the need to have unique project needs being highlighted. Various risks could occur in the execution of the contract. We need to have that also sorted. And then also warranties and intellectual property ownership. If we need also to be keen when we are receiving any machinery, we need to be keen in terms of warranty communication. How long in case of any defect have we been given, so that maybe we can request for repairs of that particular technology or item that we have requested for. And also when we are drafting the contract, we are looking at clarity and conciseness, where we need to strive to have a clear and a concise language. And this language should be very, very easy to understand. We need to avoid different forms of jargon in our contract. So we use simple and clearly understandable language that in case anyone within the organization is given an opportunity to read the contract, it is something they can be able to understand. Now, very, very importantly, we have what we call the elements of a valid contract. These elements include number A, what we call an offer and acceptance. That means either parties within the contract, one of the parties needs to make an offer. It could be the organization. Making an offer means they are writing to you as the supplier to request you to deliver this number of computers. And then that letter, once you receive it, there is what we call acceptance in law, where it is a communication that whatever offer or whatever request the organization had put forward, you are willing to take up the matter and do the deliveries. And another very, very important element is the consideration, where we have exchange of something of value in terms of goods, services, money between various parties. And also capacity to contract. All the parties that are entering into a contractual agreement need to have what we call capacity to contract. They must be legally capable. In this context, we are looking at having, for example, number A, both parties need to be of sound mind. And number 2, they need not to be bankrupt. Those are some of the legally capable persons. And number 3, they also need not to be minors or people that are below the age of 18 years. So that is the conversation around capacity to contract. And also there must be, in every valid contract, there must also be what we call a lawful purpose. That the contract's purpose cannot violate any laws and regulations. So even as we have the conversation on what kind of contract we want to execute, we are looking into having us continue to respect the law of the land in terms of, if we are in trade, what kind of goods are we trading with? Are they goods that are lawful, that are approved, or that are not violating the law of the land? Now, once we understand that particular discussion, then we come into the conversation of negotiation of contracts. And we begin by noting that preparation is very, very important. So when you are doing preparation, we need to have supporting data. Maybe we are coming today to discuss about pricing. We have very many things or issues around pricing that we need to be aware of. We need to be aware of conversations around inflation. We need to be aware of conversations of increase in interest rates. So once you have these and also so that is under negotiating of contracts. We are also saying it is not at the point of a gun that it is a must. Once you go to a negotiating table, you need to accept. The final discussion here, we are saying you have the opportunity to walk away if the conversations in the negotiation are not, you do not feel satisfied with them. But we always give dialogue a chance. If ultimately both parties require to be able to assist each other in terms of their needs. Remember, we begin by saying that in any contract, we need to identify the needs that are required in the organization. Now, it is important also for us to understand that we have various strategies for successful negotiation, and these strategies are going to ensure that we get it right in our negotiation activities, contract negotiation activities. Number one is to be able to stay strong, where we need to present a well-considered opening offer. And this offer needs to reflect your desired terms. So, and the other one, we need also to listen and understand actively. Those in the negotiating table should listen to each party's concerns and also try to find a common ground. And also, as another strategy, we are looking at a win-win solution. We come into the negotiating table looking at having every party in the negotiating table benefit. If it is the organization that is looking to receive supplies of particular goods, they can receive those supplies. If it is the supplier who is seeking to get business and supply those goods, they also get business. So that is what we call a win-win solution. And solutions also in terms of, in case we have disputes in our negotiations, then we can mutually be able to seek solutions to come into an agreement. Then also, as another strategy, we need to focus on value. As we bring on different arguments on the table during our negotiation phase, let us also look at the value aspect. Sometimes we are bargaining an item and we are not considering the value maybe this item is going to bring into the organization. We're also going to focus on understanding the legal and ethical considerations. The first one is that compliance is paramount. We need to ensure whatever terms we are negotiating comply with the relevant laws and regulations. And then also, so everything that we are negotiating on the table, the question is also, as we come into the negotiating table, what does the law say about even the kind of goods and supplies we are looking at? Would we maybe be in a conversation where some of the items that we are discussing are illegal? And then also ethical practices, where we need to uphold ethical negotiation. Yeah, so everybody coming into the negotiating table must come with clean hands. So avoid any forms of misrepresentation or deceptive tactics in the negotiating process. So that is also what we refer to as in law as the disclosure of all material facts. All the parties that are involved in the contract need to fully disclose every information. And then also seek legal counsel for complex contracts or unfamiliar legal terms. You need to consult with a qualified lawyer maybe, and this person is supposed to advise you on all matters, the legal aspect of the contract. Also, very, very importantly, we will also tonight discuss on what we call risk management in contracts. Remember, what we call risks are unexpected occurrences in the management of our contracts. And so when we are doing risk management, we are saying it is a systematic process where we identify, assess and prioritize and develop plans that are going to address potential events that could negatively impact the project. The potential events are what I'm calling unexpected events. So when we are doing risk management, we are able to identify them in advance and how we can be able to handle them. Examples of common risks in procurement of contracts include performance risks. So the contractor may not deliver on their promises. And so that includes missing deadlines, failing to meet quality standards. So the reason why we are having this conversation is to know what can we do if the contractor misses deadlines. What are the remedies that can be able to allow us sort that particular issue? Issues around quality. Sometimes you could also receive defective goods. What is the appropriate thing that you need to do to be able to get it right? And then also other common risks in procurement include financial risks. This could be conversations around unexpected costs, such as cost overruns. Sometimes we find ourselves in a situation where we are likely to spend more than we had planned for or budgeted. Those are risks. Different forms of delays or changes in the scope of the contract. And then also we could also have risks around what we call legal risks. In legal risks, we could be having disputes arising. These disputes may occur regarding the interpretation of the contract. Maybe the parties concerned have not read the contract appropriately, and they are leading to litigation or suing, either party suing each other because of those legal risks. Other risks, of course, we have operational risks. We could be having some forms of disruptions to the project due to factors like resource limitation, lack of resources, supply chain issues, and also forms of natural disasters, and relationship risks. These includes communication breakdowns or conflicts between the contracting parties, and they can be able to hinder project progress. So all these risks, it is very, very important for us to be able to discuss them in advance, knowing that because we are calling them unexpected occurrences, we may also find ourselves in situations where they are happening to us. So it is a very, very important conversation to have as we undertake our procurement negotiations. We are going also to be using a number of ways to be able to assess risk, what we call the risk assessment techniques. Number one is what we call brainstorming. And when we are talking about brainstorming, we bring together all the stakeholders where we brainstorm on potential risks. Stakeholders are everybody that is interested in the procurement process. We need to bring them in mind or have them be part of a conversation where they can be able to share what they feel are the probable risks in the procurement process. So brainstorming is a very, very good method that we can be able to adopt. Another very important technique is what we call scenario planning. So we look at possible scenarios that could find us within the procurement process, especially those scenarios that could negatively impact on the project. And we now look at the likelihood. This is where we now consider the probability of a particular scenario X happening. Like, for example, we have said missed deadlines. We could be expecting the supplier to deliver the goods today, and they don't. And also, we can also carry a very other important technique, what we call the SWOT analysis. So we analyze the project strengths, weaknesses, opportunities, and threats. And the reason why we are doing this is to be able to identify potential risk factors. So those two methods, or those three methods, are quite critical for us to be able to use. SWOT analysis, scenario planning, brainstorming, all of them have the capabilities of bringing out potential risks. And then we can also look for mitigation strategies. Other techniques that we can also use for risk assessment would be, number one, industry reports, where we review industry reports and case studies. So this one, we are looking at the past contract-related challenges. We engaged a supplier, for example, last year to be able to deliver computers in our organization. What are the issues that were raised in regards to this supplier? then we can be able to learn from those past experiences and look forward to a better relationship with maybe the current supplier or the one that is intended to receive the contract. And then also, finally, or last but not least, we can be able to use what we call the Delphi technique, also a technique in risk assessment. So anonymously, we need to survey subject matter experts that are going to help us gather insights on potential risk. For example, if we are looking to have a contract around the supply of technology, like I'm giving an example of computers, then we need experts in that particular area that understand issues around specification, that understand issues around quality. These people are going to be crucial in terms of ensuring we receive timely and proper delivery of the goods. Now, also very, very importantly, in our conversation, we talk about what we call mitigating contract risks. When we are talking about the term mitigating, is simply answering the question of how do we deal with. So contract clarity, we need to draft a clear and concise contract. And this contract is going to outline various expectations, roles, responsibilities, risk allocation. So we need the contract to be very, very clear. And also performance guarantees, where we include performance guarantees in the contract. For example, what we call liquidated damages. So in case a supplier misses a deadline, we could be having in our contract what are the likely consequences of such a supplier. And then also around insurance, we need to consider purchasing insurance to mitigate specific risks. This is a conversation now that it's taking shape. Issues around insurance. We could be having a supplier who is transporting goods, then along the way, maybe hijacking happens, the loss of goods happens. So what is it that we can be able to do? And also, other ways that we can mitigate contract risks is through risk-sharing agreements. So we can negotiate risk-sharing agreements. The supplier, the buyer can negotiate. Remember, we have just talked of something we said, a win-win situation. So these negotiations are critical. Yeah. Especially for this particular point, then we are going to ensure either parties is able to bear the burden of potential cost overruns and delay. Yeah, so it's also a very, very important way of mitigating contract risks. And also a very important point, finally, is open communication. So we need to maintain an open communication, a transparent communication between the buyer and the seller. This is going to make it easy. That, for example, in case we are having what you are calling delays in terms of delivery, then there is official communication to that matter. That delay is going to happen, and this is how we are going to do so that we compensate on the time lost. Then we are going to look at what we call developing a risk mitigation strategy. When we are developing a risk mitigation strategy, number one, we identify risk triggers. Who are the risk triggers? These risk triggers determine the events and conditions that could trigger each risk identified. Remember, there's a place where we have had an opportunity to list all the risks. So what are the likely triggers that could find us in a particular risk X? And then from there, we need to develop action plans through developing action plans, we create specific action plans to address each risk. We now able to outline who will be responsible for taking action and what steps will be taken. And also we do what we call contingency planning, where we develop plans for high impact risks. And when we are doing these plans, we want to outline various courses of action if those risks materialize. So when we are putting in a contingency plan, we are now telling us that in case a risk happens, this is what we are going to do about it. And also we do what we call regular monitoring. So we ensure regular monitoring of the project for signs of emerging risks. When we are doing monitoring, of course, it is a continuous process. We have to make sure we are doing it. We have to make it sure we are doing it and we are doing it right. By doing so, the main purpose of monitoring is to ensure we are continually watching what is happening. And we are able to, we are alert that in case we are found in a particular situation, we have already put in place ways of dealing with that particular risk. Over and over again, we are going to be having disputes arising in matters resolution or in matters contract engagements. So we are saying these disagreements are inevitable and may arise at any point of the contract, negotiation, execution, when it is the time to pay. So we are looking at ways that we can be able to resolve those disagreements once they arise, or those disputes. So it is very important also on our contract, we put a dispute resolution process. And this process is going to provide a clear framework for resolving disagreements that may arise during the course of the contract. Methods for resolving contract disputes. We have a number of ways we can resolve disputes. Number one, and one of the most common ones, is the negotiation method. So parties will just come together, talk to each other, and try to reach a mutually agreeable solution. And then we have mediation method. The mediation method will look to have a third party come on board. This person is the person we call a mediator, and they are going to help us push the communication between the parties and help them reach an agreement. We can also use what we call arbitration, and we are saying an arbitrator is a neutral person, somebody who does not have an interest in the contract or in the execution of the contract, but they will bring into the negotiation what we call expertise in a particular field. And that's why in a particular slide we were talking about the need to engage a lawyer, especially in these negotiations, so that nothing can go wrong. And finally, final method for resolving contract disputes is what we call litigation. So it means that we get to a point where we are unable to resolve these issues, and then these matters are taken to court, and the judge will have an opportunity to make a ruling or give a ruling depending on the issue at hand. So the determination of which method to use is not a must, or it's not specified that it should be method X, but we look at various situations and see out of the methods that we have discussed here, which one will be the most appropriate for us to be able to resolve contract disputes. So that particular slide brings us to the end of our lecture tonight. Unless there is any question, I wish you a good evening, and hopefully we will be meeting soon. Enjoy your evening.